Live.
Good afternoon again. It is still January 27th, 2022. This is part two of the House Judiciary Committee's bill hearings today. Where we last left off on our story, it was with House Bill 153 and Delegate Crutchfield. We stopped in the middle of the testimony of those people who were testifying in favor of the legislation. There are several people who are going to be testifying now in favor of the legislation, and we're going to give them each 1 minute to testify. And let's just call all of them as a group, the ones that are remaining. That is Ashley Inderfirth, Michelle Seary. Let's see there. Dina Sarincian, the state's attorney, the new state's attorney in Washington County. And I think I have screwed up her name twice now. Dorothy Lennig, Michelle Smith, and Melanie Shapiro. We'll hear from all of them, and then we'll take questions after that. Delegate Crutchfield also being available to answer questions as well. So with that, a minute, please. Ashley Inderfirth.
Thank you, Mr. Chairman, and thank you, members of the committee, for allowing me to speak today in support of this bill for the repeal of the spousal defense on behalf of the Montgomery County State's Attorney's Office. I wanted to share with you a case that demonstrates the imperative nature of why this law must be repealed. I had a case a couple of years ago where a wife woke up suddenly. She was on her stomach, her legs were spread, and she was naked. There was a laptop in between her legs, taking close-up videos of her most intimate area as fingers penetrated her. Her husband was operating the camera. She demanded that he show her the website he'd been on, and he pulled up the site, and she was horrified to learn that it contained dozens and dozens of close-up videos of her genitals. You can see that she is asleep, yet her husband was videoing himself manipulating her vagina, placing items inside of her, and having vaginal intercourse with her. She had no idea that these events had happened and had never consented to him using her body in this degrading manner. The detective brought the case to me, and I intended to charge the husband with rape for each charge, until I learned that in Maryland, a person cannot be prosecuted for rape if the victim was their legal spouse at the time of the offense, and the act did not involve the use of force or threat of force. Honorable delegates, I had to tell this woman that I could not prosecute her rapist because her rapist was her husband. How is it possible that in 2022, a marriage certificate can be a shield for a rapist to avoid accountability? I respectfully ask that you issue a favorable report, because the repeal of this law will place all rape victims on equal footing under the law, regardless of their marital status.
Thank you very much. We'll go now to Michelle Seary for 1 minute, please.
Thank you. Good afternoon, Mr. Chair, members of the committee. My name is Michelle Seary. I'm the Executive Director of the Women's Law Center of Maryland, statewide legal services and advocacy organization. I'm also here on behalf of the Maryland Legislative Agenda for Women. HB 153 is part of MLaw's agenda of bills that its organizational and individual members are supporting this year. I'm here to state unequivocally that one's marital status should never define one's ability to control their own bodily autonomy. According to the last census, over 137,000 people lived with an unmarried partner in Maryland. Those people were all entitled to file criminal charges for unconsented to touching. There has been no evidence that the ability to do so has wrecked those relationships or resulted in trumped up charges and prosecutions, and yet married individuals are not afforded the same right to say no means no and have it mean anything. There is no way that our laws can be considered more just by that dichotomy. Every individual should be empowered to claim their own bodily autonomy. This includes men and women. It includes people of all races, faiths, nationalities, and disability status. Our laws should not be any different for married individuals. And for those reasons and those stated by all the other panelists, I urge a favorable report on HB 153. Thank you.
Thank you very much. We'll go now to Dorothy Lennig for 1 minute, please.
Good afternoon, Mr. Chairman, members of the committee. My name is Dorothy Lennig. I'm the director of the Domestic Violence Legal Clinic at the House of Ruth. We serve victims of domestic violence throughout the state of Maryland. I'm here today to urge a favorable report on House Bill 153. Domestic violence is serious, and it's a crime. In past years, some people have suggested for this kind of fourth-degree sexual offense that somebody should just get a civil protective order rather than press criminal charges if they're married. And for those of you who are new to the committee, a fourth-degree sexual offense involves touching without consent in an intimate area for the purpose of sexual gratification. So why would an unmarried person be able to press criminal charges for this act, but a married person not be able to? Clearly, a protective order is an option, and it should be an option, but so should criminal charges. Right now, a married victim can press assault charges, stalking charges, sextortion charges, revenge porn, any of those things against her husband, but cannot charge somebody with fourth-degree sexual offense. So married people should have the same rights as unmarried people. This is 2022. Certainly it's time to change it. Urge a favorable report. Thank you.
Thank you very much. Ms. Shell Smith for 1 minute, please.
Thank you, Mr. Chair, Vice Chair, and members of the committee. I echo all of the comments made by the delegate who sponsored this bill, hello, Delegate Crutchfield, as well as the other panelists. And in addition, with regard to who I am speaking for today, which is the Maryland State Bar Association Family and Juvenile Law Section Council, we specifically urge a favorable report on this bill because it is time. This law is arcane. It does not provide equal opportunities to the justice system for married people, and specifically in the area of divorce. In that context, all forms of domestic violence, including the ones available to non-married parties in criminal cases, are admissible as factual predicates to grounds for divorce, claims for custody, and even divisions of assets under our current marriage law and divorce law. So why would it be that a married person could introduce that very same evidence in their divorce case or in a domestic violence protective order case, but not in a criminal case? It is simply not fair, and it is time to change that. We urge a favorable support.
All right. I believe that I missed Gina Surincian.
Surincione, yes.
Yes, Surincione. I apologize. Please go ahead for 1 minute.
Certainly. Mr. Chair, honorable delegates, I am here today on behalf of a victim in Washington County. I've been prosecuting sex offenses for 28 years. I'm in support of Bill 153 because of what my victim endured on February 8th, and actually for a 3-year period. She and her husband each drank a beer on February 8th, and Dana, the wife, soon lost consciousness. When she regained consciousness, she was naked from the waist down and had duct tape around her wrists. Based on the taping, her wrists at one point were bound together. Through the investigation, it was determined that her husband had been drugging her and raping her for 3 years and videotaping these incidents on his cell phone. Because of the marital defense to sexual offenses, I was unable to prosecute Dana's husband for rape or any degree of sexual offense or any felony. I was only able to charge the defendant with misdemeanors when felonies were certainly warranted for this deplorable behavior. And we believe it's unconscionable that this conduct was not prosecuted as a rape. There are other ways that rape can be committed that are exempted from the spousal defense. However, we can't just amend this law to include new ways that these crimes are perpetrated. We need to repeal it. We can't imagine what people do to one another, and we don't know how often we would have to come back to this body and say we need this exception. So we are asking that you repeal Statute 33810 in its entirety. Thank you.
Thank you very much. We'll hear now from Melanie Shapiro for 1 minute.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm Melanie Shapiro, the Public Policy Director with the Maryland Network Against Domestic Violence. We are asking for a favorable report on House Bill 153. You have heard from many excellent panelists already, so I will not reiterate everything that they have already said, but understand that we are sitting here in 2022 and we are stuck back with a law that goes back to 1847. This law was created through English common law when women were considered the husband's property, and a marriage contract meant a woman consented to all marital sex, including rape. I think that in this day and age, in 2022, we should understand that it is not, marriage is not a defense to any form of sexual assault. And this is in fact a real problem. Approximately 10 to 14% of married women will be raped at some point during their marriage. So it is incredibly important to those victims that we in fact pass what HB 153. And so we are urging a favorable report.
Thank you very much. Thank you. That concludes the witnesses. Is there anyone who has a question for any of the witnesses or for Delegate Crutchfield on the legislation? Delegate Bartlett.
Thank you, Mr. Chair. Thank you, Delegate Crutchfield, for bringing this bill back. I have a quick question. Are there other defenses that would be available to anyone who was being tried or being charged with sexual assault? Would those defenses be available to a husband if he raped his, or if he was accused of raping his wife?
Would one of the panelists like to comment?
Thank you, Delegate Bartlett, for that question. All defenses would apply. This is just a special exception that exists in the law for married couples. So in the situation, as has been discussed, if the partners were not married, they could be charged with this, and all of the defenses would be available to that individual. In a situation of married couples, all those same defenses, but the fact that they were married and so in some way consented to the sexual assault would not be able to be a defense.
Right. So
there's like a duress or something like that would be available.
So essentially what I was hearing from one of the state's attorneys is that essentially what this does is it doesn't even allow, what the law does currently, doesn't even allow the facts to be heard where there is a husband and where there is marriage involved. The facts aren't even heard. So there's no charges brought or anything. And it's almost like there's just a presumption that is made that doesn't really make sense. And so here's my point again. So I want to make sure the defenses, all the defenses that any other individual would have who's charged with sexual assault or rape would be available. This is not a defense that is a necessary defense. I want to make sure I understood.
Yes, thank you, Delegate Bartlett. That's absolutely, you said it perfectly. And I think the point that you made regarding the charges not being brought is so important. But because this marriage defense exists, when the prosecutor's office investigates and has to determine if they have sufficient grounds to bring a case, they know that the marriage is an absolute defense to some of these offenses. And so they can't even bring the charges because of the defense. If the marriage piece is taken away, all of the other defenses available under criminal law still exist, but they could in fact pursue a case against an individual, and a case that would charge the person with acts that they in fact committed, as opposed to charging them potentially with something else that they couldn't charge them with this because the partners are married.
Thank you. Absolute defense. That's what I was looking for. Thank you very much. Thank you, Mr. Chair.
Thank you very much. Are there further questions for the panel? Seeing none, we thank you all very much for your time and your patience as we've gone through a bit of a day here. That concludes the testimony of House Bill 153. We will move on to our next piece of legislation, and that's House Bill 161, and this is Delegate Shetty's legislation. All right, and we will look at the list here, and there are 1, 2, 3, 4. There are 5 people to testify in favor of the bill. There's no one signed up to testify opposed. So we'll go ahead and we'll hear from everybody. This is a reintroduction of a previous bill.
Excuse me, Mr. Chair.
Oh, wait a minute. That's right. Delegate Shetty is in Ways and Means for a hearing. So never mind that. Sorry. I think we're going to Delegate Cardin then, right? I think. Dylan will tell me if I'm wrong again.
Correct.
The 600th time probably today that I've been wrong. I'm going for the record. All right, let's try House Bill 121 then, shall we? Delegate Cardin. There's, well, let's see. There are 3 people signed up to testify in total. Delegate Cardin's going to testify. Melanie Shapiro favorable with amendment. So we'll hear from her as well as Delegate Cardin. Then we'll take questions. Then we have Mr. McAvoy in opposition. This is a new bill, so 3 minutes for Delegate Cardin, 2 minutes for everybody else. And with that, I will finally shut up and allow Delegate Cardin to present the bill. 3 minutes, Delegate Cardin.
Thank you, Mr. Chair, members of the committee. For the record, John Cardin on behalf of House Bill 121. And let me just say, since I have now 3 minutes and it's not going to take me, I don't think it's going to take me that long. Mr. Chairman, you're never wrong. When you make a decision, that decision, whatever that decision is, it's the right decision.
Okay. All right.
Okay, the intention of House Bill 121 was to correct a wrong dealing with Grace's Law. And you will all remember that I am very emotionally charged when it comes to cyberbullying and the prohibition of cyberbullying. And the issue that we have is that there could be 2 minors who are in fact engaged in some sort of toxic cyberbullying. And when one tries to file a peace order against the other, the Department of Juvenile Services was required to sign off on it. And as we were finding out, and I was getting a lot of calls about this, the Department of Juvenile Services just was not interested. This was not serious enough, or they were not involved enough to really understand, and they were not necessarily signing off on these peace orders. And we needed to make sure that if somebody wanted a peace order, just have somebody else stop emailing him to go kill himself or to go hurt himself. We wanted to get that to stop. So the intent of the bill, and we tried our best, was to just take juvenile services out of the equation and just have this go directly to the juvenile courts and the circuit court of the jurisdiction. That was the intent of the bill. The bill does not do what it is intended to do. It does not do it effectively. I had a great conversation with many advocates, including Ms. Shapiro, who will be testifying in a few moments. And we have decided to draft an amendment, which the committee, all the members of the committee should have it on their computer. And if you don't, I'll make sure you get it. And what the amendment does is, because we could not come up with language to do what I just described, the language is to require data to be retrieved from both Department of Juvenile Services and the courts system, the judiciary, on how many of these are being filed, how many are being violated, and some disaggregated information about the people who are filing them and where they are filing them. Once we have that information, we believe that we can file new legislation next year, God willing, that will actually do what it's supposed to do and make sure that the people who need these peace orders, and if I said protective order, I meant peace orders, are getting them to keep our children safe. Thank you, Mr. Chairman.
All right, let's hear from Melanie Shapiro, please, for 2 minutes.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Melanie Shapiro with the Maryland Network Against Domestic Violence. We are the State Domestic Violence Coalition. So I would like to thank Delegate Cardin for bringing this bill and for working so closely with us. As he explained, the way that the peace order process works, if there is a child who is under the age of 18 that somebody is seeking a peace order against, it goes to the juvenile court system. They need to petition. And then the Department of Juvenile Services then determines whether or not to forward that petition to the court or not. And the issue there is that sometimes they're not forwarded. What we don't know is how many there are that are not then forwarded. And to fully repeal the peace order process, the challenge becomes there's then no jurisdiction for juvenile peace orders, because the district court doesn't have jurisdiction over juveniles and the circuit court does not have jurisdiction over peace orders. And so there are certainly challenges. And I think once we get this information, we would have a greater picture to understand what reforms, if any, are necessary within the peace order process, and to understand the reason why it's relevant for victims of domestic violence and victims of teen dating violence is that if the partner is under the age of 18 and they don't meet the criteria otherwise of a peace order, of a protective order, then they would be able to pursue a peace order in the juvenile court. So we are supporting HB 121 and urge a favorable report with the amendments, with the sponsor amendments. Thank you so much.
All right, are there questions for Delegate Cardin or Ms. Shapiro? I guess my overall question is, does this, if you and I'll admit that this isn't necessarily an area that I have a lot of personal experience. Well, professional experience. Let's go. No personal experience, no professional experience either. I guess my question, if you take a peace order out of the process where it's going into the juvenile court, is there a risk that this ends up on case search, that it ends up being available more publicly than it would before?
That was what, thank you for the question, Mr. Chairman. That was actually one of the things that we did discuss. And Melanie, please correct me if I'm wrong, but all juvenile matters are shielded from any kind of public observation in the first part. But the other issue, there's nothing that happens in the juvenile court system that is more public than what happens in the Department of Juvenile Services. The problem is that the information, or we do not believe that Juvenile Services is managing, or we're not sure, we don't know whether they're managing the situation correctly, and therefore these cases are not being managed, and these children could be suffering. So the idea is to strike this bill, get the information as to whether there's a problem or not this year, use the amendment as the bill to just get the information as to what is happening, not change the law at all at this point. And then next year, if in fact we find out that there's 5 cases that they didn't forward statewide, that's different than if we find out there are 500 cases that were not forwarded and no action was taken statewide. And so that's kind of, and maybe the cases were 2 boys versus 2 girls versus a boy and a girl. Like, we just want to know, disaggregate all the information, find out what we're talking about in terms of requested peace orders, then figure out, maybe with the help of the committee, figure out the best way to make sure that people are getting the protections they need, these young people.
I muted myself. Let's go to Delegate Crutchfield with a question.
Thank you, Mr. Chair. So Delegate Carton or Ms. Shapiro, I guess I want to make sure I totally understand the process. So what you're basically saying is that a peace order is not under juvenile jurisdiction until it's signed off by DJS? Oh, okay.
So, thank you for the question, Delegate Crutchfield. So when you look at the juvenile jurisdiction law, so if you're looking in courts and judicial proceedings like 3801 and 3802, when it talks about juvenile jurisdiction, and if you can just look at the bill and see how many places it says and peace order. And so it's under juvenile jurisdiction because we are talking about children. And so there is definitely many benefits for being in juvenile court. The challenge becomes, if we really don't have an answer to, is the cases then go kind of through a DJS intake process. If somebody wants to petition for a peace order against a juvenile, they go to the Department of Juvenile Services. But we don't know then what happens. And there's power within DJS to decide whether or not to authorize that petition or not. If you were to go to the district courthouse to file a peace order against an adult, you go see a commissioner. Nobody then decides this is good enough, this isn't good enough. The commissioner makes that decision when you go before the commissioner. And so DJS is standing in between a juvenile and the court at this point, and we don't have the information to know how many are being stopped at that point. And it could be none, it could be many, it could be an appropriate amount. We just don't know that information, and we think it's important to understand what's happening at that stage, and that's why this bill and proceeding by way of getting that data first is really important before we make any changes.
Okay, great. So this is really now a bill that just deals with data collection. Is that correct? Okay. Thank you.
That's correct.
Are there further questions for the panel? Seeing none, thank you all very much. I believe Mr. McAvoy is no longer here, so we won't have anyone in opposition. He is not here, so that concludes testimony on House Bill 121. Thank you very much, Delegate Carter. Now, Delegate Shetty has returned from her expedition to the Ways and Means Committee and is back with us again. And so we'll begin with House Bill 161. Again, as I was saying before, it looks like there are a total of 5 people set to testify. We'll see how many are still here, but my intention is for Delegate Shetty to testify. This is a reintroduction, so 2 minutes for Delegate Shetty, Ted Meyerson for a minute, Robert Hill for a minute, Brian Rosland for a minute, Kenneth Grigg for a minute, and they are the only people signed up to testify. So with that, we will start with Delegate Shetty and House Bill 161 for 2 minutes, please.
Thank you, Mr. Chair. Chair Clippinger, Vice Chair Moon, members of the Judiciary Committee, thank you so much for the opportunity to testify in support of HB 161, a bill that will strengthen our laws to protect seniors and vulnerable adults from undue influence. Does this sound familiar, friends? Of course it does. It's been previously passed by this committee twice, both in 2020 and 2021 unanimously. In 2020, it passed the House unanimously, but then we adjourned too early and the Senate couldn't get to it. In 2021, it passed the House on a near unanimous consent calendar vote, but it has not yet made it through the Senate. I'll add that last year, JPR did consider it. However, because there were 2 bills related to undue influence, mine on the criminal side and the vice chair's on the civil, the committee chose to pass the Senate version. As you may recall, and for our new members, undue influence is a legal doctrine that dates back to a common law case in 1617. And although our understanding of undue influence has evolved, our laws across the country and here in Maryland have not kept up. These cases are super difficult to prove, in part because they are often behind closed doors and without witnesses, and the law lacks a clear definition for what undue influence is. The issue is often complicated by the assumption that mental capacity and undue influence are linked, which is not always the case. For example, one can be of sound mind and still fall prey to undue influence due to other factors like the relationship between the influencer and the victim. This bill will strengthen our criminal code as it pertains to the definition of undue influence of a vulnerable adult, specifically as it relates to the transfer of property. The idea came by way of my constituent, who also happens to be the constituent of the vice chair of JPR, Claudia, whose late uncle was defrauded by their financial advisor. His advisor convinced the uncle to place the advisor into the uncle's will as the sole beneficiary prior to his passing. It's really important to note that there was a civil suit that was settled and a criminal case was not pursued, in part because the standard in Maryland is so difficult to prove that cases like these are very rarely successful. Claudia remains a great supporter of this bill and is very hopeful that the criminal code will at last be amended. It's our shared hope that other families in her position will have the opportunity to hold people abusing their positions of influence over vulnerable adults accountable. We connected with her recently. She shared that her understanding was that the bill that passed last year, was meant to complement mine, and she will cheer very loudly when this one passes. Thank you so much for your reconsideration of the bill, and I urge a favorable report.
Thank you very much. Now for a minute, Ted Meyerson from the AARP.
Mr. Chairman and committee members, my name is Ted Meyerson. I'm an AARP Maryland volunteer. I'm also a member of the National AARP Fraud Watch Network and a guest member of the International Association of Financial Crime Investigators, the IAFCI. The Fraud Watch Network is constantly trying to keep track of frauds and scams. Last year, nearly 100,000 people called its hotline. That's an average of close to 300 per day. At every meeting, the IAFCI investigators share stories of financial crimes, many perpetrated against older Americans. So I hear a lot about financial abuse. The thieves are very clever and convincing. Recently, an old gentleman in Poolsville lost $200,000 to a home improvement scammer who knocked on his door and convinced him he needed work done. Undue influence is a problem, a known problem of over $3 billion a year. And with the unknown contingent estimated to be as much as $56 billion a year.
Mr. Meyerson, if you would Wrap it up.
I'm wrapping up right now. The House Bill 161 further defines undue influence, and the law should give enforcement broader powers, a bigger net against criminals who victimize older adults. So AARP stands in favor of this legislation and requests a favorable report. Thank you.
Thank you very much. We'll go now to Robert Hill. 1 minute, please.
Thank you, Chair Clevenger, Robert Hill, on behalf of the Montgomery County State's Attorney's Office. I want to thank Delegate Shetty for all of her work on this. This is a very important bill, and I believe will make it much more effective for prosecutors to prosecute cases involving financial abuse of vulnerable adults. As she said, I think what it does is it brings the definition of undue influence into modern times. The problem we run into is, as the current definition suggests, is it requires that I show force or coercion. The cases that I get don't involve force or coercion. They involve grooming. They involve, apparently kind caregivers who gain trust with the person and ultimately steal right out from under them. It doesn't. Our cases don't involve the force that the statute suggests. So I think that what is important here is the statute provides the court with a number of factors that it should look at. It looks at what the vulnerability of the victim is, what the defendant's apparent authority is. This is a family member, a care provider, or otherwise, and whether the defendant knew or should have known that the victim was a vulnerable person. And we think these are very important. There's a statute in California, I believe, yes, 2 seconds, that is in place. And thank you, but this would be very important to prosecutors. We urge a favorable report. Thank you.
Thank you. Brian Rossland now for 1 minute, please.
Thank you, Mr. Chair. What this statute does, as Mr. Hill articulated, is it patches a hole. And we essentially have this problem with force and coercion, bringing up the idea of some guy showing up on your doorstep with a lead pipe. That's not how thieves work these days. They rely on the ability to gain trust and to take money from people. I'm head of the Crimes Against Seniors and Vulnerable Adults unit in Montgomery County, along with Debbie Feinstein, and been doing financial crimes for 20 some years. And so it is, looking at this statute, that undue influence has, as it's defined with force and coercion, has always proved too high a hurdle. It is a narrow group of cases that this addresses, where we can't use deceptions, where we can't use some of the misappropriation by fiduciary charges, but it is a real piece where we are seeing victims regularly with it. We would ask the committee to give a favorable report.
All right. We'll go now to Kenneth Grigg, please, for 1 minute. Mr. Grigg.
Kenneth Grigg. Thank you, Chairman Clevenger, Vice Chairman Moon, and members of the committee. I'm here and on behalf of the State's Attorney, Aisha Braveboy, for Prince George's County and the Maryland State's Attorneys Association. I'm testifying to show my support of House Bill 161, which is sponsored by Delegate and Deputy Whip Shetty of Montgomery County. I urge a favorable report on this bill. The proposed bill will define the vulnerability of a victim whose property is obtained by undue influence in the context of the exploitation of a vulnerable adult or elderly individual over 68 years of age. The bill provides 10 instances, some of which Mr. Hill went into, in which the court may find a victim vulnerable in this context. It has 7 categories of the defendant as having apparent authority to have authority over the property of the victim. The bill goes on to define the actions the defendant takes in the context of controlling the victim of his or her property, using excessive persuasion and using haste or secrecy to control the victim's property. And it's that excessive persuasion that'll help us. It would have helped me win a case I lost in November, because we had a grandson taking advantage of the grandmother, and he was using excessive persuasion and overcoming her defenses, and she was writing checks to him, and the other family members were alarmed and got us involved in the case. Jury was out two hours and then found not guilty. And that is a specific instance where that this would have helped. So I would urge the favorable report of this bill and join with Brian and Robert Hill. Thank you.
Thank you very much. Are there questions for this panel? Delegate Bartlett.
Thank you, Mr. Chair. My question is for the bill sponsor, Delegate Shetty. So you mentioned that the bill had passed unanimously in prior years. And I just wanted to double check, are there any changes between this year's bill and the last two that passed unanimously?
Yes, thank you so much, Delegate, for the great question. So the state's attorney's office in my county, in Montgomery County, requested that we remove the previous language of amounting to force and coercion from the bill, because as referenced by Mr. Hill on my panel, in today's world, that's just not really something that happens in the type of cases that we're trying to address. And so, for example, like internet phishing scams, they often involve skilled requests from a perpetrator or exploiting an elderly or vulnerable person's fears or lack of resources. So removing that language actually improves the bill, I believe, and helps address this issue that we've, as a committee, been working hard to pass for a couple of years now. Thank you, Delegate.
Thank you. Thank you, Mr. Chair.
Thank you. Are there further questions for the panel? Seeing none, we thank you all very much. And that concludes the testimony for House Bill 161. We'll now move on to House Bill 110. And this is another piece of legislation from Delegate Shetty. There are 7 people who are going to testify orally, 1 person testifying for informational purposes, so we'll hear from them last. This is a new bill, so 3 minutes for the sponsor, 2 minutes for everybody else. It'll be Delegate Shetty, then Debbie Feinstein, Sarah Proctor, Catherine Marsh, Jessica Garth, and Brett Engler from the MSAA. Then after that, we'll take questions. Then we'll take testimony from Megan Tarquinio from the Frederick Health Hospital. Right. So let's go ahead and we'll hear from Delegate Shetty then for 3 minutes. If you're on just joining us, you need to put there you go, on mute. How about that? Now we'll go with Delegate Shetty. Here we go for 3 minutes.
Thank you, Mr. Chair, Vice Chair Moon, and members of the committee. Thank you for the opportunity to speak with you today about House Bill 110. HB 110 will alter the penalties for stalking in 2 very specific, only 2 circumstances. If the victim had a protective order in effect against the defendant at the time of the offense, or if the defendant had previously been convicted of stalking. Domestic violence and other violent crimes, particularly crimes committed against women, often have prior stalking incidents. Currently, Maryland is the only state without enhanced penalties for stalking. Stalking is also not classified as a crime of violence in Maryland, although it is statistically heavily correlated with abuse and murder. Because stalking usually involves other non-criminal behavior, it is often regarded as a criminal misdemeanor, which only carries a 5-year maximum sentence and a $5,000 fine in Maryland. HB 110 would alter this penalty to a felony with up to 10-year sentence and $10,000 fine in only those 2 circumstances I spoke of earlier: repeat offenses or a violation of an intimate partner protective order. HB 110, as before you today, mirrors other enhancement statutes in Maryland, altering the previous law by doubling both the sentencing time and the fine. HB 110 also ensures that stalking is penalized in these 2 circumstances, whether or not the person previously convicted of stalking, was here in Maryland or in another state. I will add that while I do personally believe that there is a need to meaningfully address stalking under these 2 circumstances, if it means that we're potentially saving lives, There might be amendments that we may want to consider to ensure that we are able to do this while also ensuring that we're not increasing penalties unnecessarily nor excessively in the process. I welcome further discussion with my committee colleagues and advocates on how we can best achieve this. Thank you for your consideration of this bill, and I would be honored to answer any questions you might have.
Okay, we'll go to Debbie Feinstein next for 2 minutes now, 2 minutes.
Thank you. Good afternoon, Chairman Clippinger and members of the Judiciary Committee. My name is Debbie Feinstein, and I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. My division is responsible for prosecuting domestic violence, stalking, sexual assault, child abuse, etc. in our county. There's some startling statistics around the crime of stalking. There's a 2011 study that notes that 77% of stalkers commit new offenses within about 100 months of their first conviction for stalking. And over half of them, 56%, were charged with new stalking offenses. And the other of the, 44% that weren't charged with new stalking offenses, 33% were charged with violent crimes, including sexual offenses. These are significant statistics that demonstrate the importance of having a heightened penalty where someone is a repeat offender. Stalking is incredibly dangerous. I could spout lots and lots of statistics, but what I'll mention to you most significantly, and Delegate Shetty already spoke to this, and I'll just give you some specifics. Stalking is highly correlated with homicide. 76% of female homicide victims in a study had been previously stalked. 54% of female homicide victims had reported their stalking to the police before they were killed. The remainder of that percentage may have reported it to a friend or someone else instead of to law enforcement. Again, startling and very concerning statistics. We also know that the overall statistics in the United States are that 1 in 12 women are stalked and 1 in 45 men are stalked during the course of their lifetime. Stalking is an underreported crime. It's an underinvestigated crime, as I know some of my colleagues will speak to. And one of the significant concerns that we have is that we need additional resources and focus by law enforcement on stalking. By making it a felony, we hope to accomplish that. By making it a felony for repeat offenders, by making it a felony for individuals who have a protective order at the time that they are stalked. I can give you numerous examples. I was just looking at one for my jurisdiction. There are many, many, many examples of stalkers who stalk their victims even after a protective order has been issued against them. We have a recent case where an individual stalked his victim, told her that he was going to hurt her, told her that he was going to kill her. This was, again, after the imposition of a protective order. He came to her house multiple times, burglarized her home, and she lives in fear. Thank you so much for your consideration. I urge the support of House Bill 110. Thank you.
Thank you very much. Sarah Proctor, please, for 2 minutes.
Thank you, Mr. Chair and committee. I am a local prosecutor. I was in Charles County for about 6-7 years. I am with St. Mary's County now. I primarily do the SVU cases. Sarah Pitt submitted written testimony in favor of this bill. I am asking for a favorable report also. If you had a chance to review her written testimony, that case spanned in court. The court process started in early 2019 and did not wrap up till the end of last year. He was charged and released for stalking-like behavior and stalking 3 different times. She had a protective order, he violated, and he got released. Time and time again, from the district court commissioners to the district court judges to the police involved to serve the warrants, it's a misdemeanor, it's a misdemeanor, it's a misdemeanor. The components of the judicial system prioritize reactions and resources on the classification of the crimes. In this particular case, once we had him held, we transferred the case to circuit court. While he was pending a court order, admonished by a judge, contact her again and you will go to DOC. Did he contact her again? Yes. Letters from the jail, letters to her family. St. Mary's gives tablets to the inmates, so text messages to her from the jail. Third party, inmates giving out her phone number to text her from the jail. Jail calls from other inmates to her. He was in need of mental health treatment, was his attorney's recommendation, which we all agreed, because now after a court order, she is still going through this with a judge telling him to knock it off and he doesn't. So we sent him to an inpatient facility after an evaluation. He manipulated his care worker, if you will, to use the phone to call his attorney. He did not call his attorney. He called the victim. He was brought back immediately to the jail and held until his trial, which ended up being a plea and sentencing. The statistics that Ms. Feinstein gave you, well, this individual, it took 4 months for him to reoffend. He is back facing charges in Charles County for another victim who went and got a protective order, and he has since violated it. So it took him 4 months. I will just wrap up with this. In St. Mary's, we currently have a homicide involving a six-year-old female and her mother due to stalking-like behavior from when she had a protective order and everything out and did everything right. And now we are prosecuting him for their murders. I'll wrap up with that and ask for a favorable report. Thank you.
Thank you very much. Catherine Marsh, please, for 2 minutes.
Good afternoon. I'm Catherine Marsh, the Special Victims Liaison for the Charles County State's Attorney's Office. On April 28th of 2017, 8-year-old Jay was located by a neighbor outside, appearing shocked and confused. Police responded and located his mother, Tanya, shot and killed. The investigation revealed that Tanya had separated from her husband. When she left the marital home, he began stalking her. She changed her phone number 3 times and went from one family home to another. She worked for the Department of Corrections. Her employer observed the defendant's stalking behaviors, made a report, and helped Tanya obtain state services. Tanya applied for 3 protective orders within a 1-year time period, the last one just 4 months before her death. In that hearing, she testified about the defendant's stalking and his threats, specifically stating he would see her in a coffin and the only way she would leave the marriage is if one of them was dead. I played Tanya's testimony at her sentencing, a stark reminder that she had asked for help and predicted her death. The victim had sought help from the courts, her employer, and 8 days before her murder from her primary care physician. After her murder, a thorough investigation was done, search warrants, interviews with numerous friends, cell phone mapping, all which proved the stalking and showed the defendant would show up wherever the victim was. These are all tools that are not used for a simple misdemeanor charge. This murder, witnessed by her 8-year-old son, was preventable. We failed Tanya. We failed her family. She went to the courts for help and the defendant was never locked up or even ordered for a psychological evaluation. She looked for help from her employer and doctor, and the defendant stayed free. Her case is unfortunately not unique. As you heard, 54% of female homicide victims have reported stalking to the police before they were killed. Maryland is the only state that does not categorize repeat stalking or stalking when there is an active protective order as a felony which under federal law would have prevented the defendant from being able to obtain a gun. Maryland is the only state that does not recognize enhanced penalties for repeat stalking offenders. We need to do better. We need to not fail any more victims.
Thank you very much. We'll go now to Jessica Garth, please, for 2 minutes.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Jessica Garth, and I'm the Chief of the Special Victims and Family Violence Unit at the State's Attorney's Office for Prince George's County. I'm here to show my strong support for House Bill 110 on behalf of the State's Attorney Aisha Braveboy and the MSAA, and to ask for a favorable report. This bill enhances penalties for some of the most serious offenders in our community, those who have been previously convicted of stalking or who have a court order already against them. These individuals have shown they're willing to engage in this type of behavior even after adjudication by the court. They are dangerous both to our communities generally and to the specific victims in question. Classifying an offense as a felony has a significant impact. In my office and many others throughout the state, felony domestic violence offenses are screened vertically, meaning a specialized prosecutor becomes involved in the case much earlier in the investigative process. Our investigators and prosecutors have more resources to give to felony charges, which results in more favorable outcomes and decreased recidivism. The importance of decreasing recidivism in these types of cases cannot be understated. A significant number of these offenders go on to commit crimes of violence, including murdering the same victims who stood up against them previously, as you've heard from my colleagues. Victims of stalking deserve more protections than they are getting, especially when their stalkers have already been given a second chance. I urge a favorable report on this bill, and I thank you for your attention today.
Thank you very much. We'll hear now from Brett Engler, please. Mr. Engler?
Do you hear me?
Brett Engler? Oh, there you go. I'm sorry, I said Mr. Engler. I didn't see your picture. Ms. Engler?
Can you hear me?
Barely.
Can you hear me now?
Yes.
Okay, I'm going to be close to my mic. Thank you, members of the committee. I'm Brett Engler. I'm the chief of the domestic violence unit here in Frederick County. My unit handles everything related to intimate partner violence, from misdemeanor protective order violations to domestic homicides in Frederick. I won't belabor the point, but as Debbie and everyone else said, stalking is highly correlated to lethality, particularly femicides, the murder of a female, in intimate partner violence. According to Dr. Jacqueline Campbell, 54% of female domestic violence homicide victims have reported stalking to the police. But I've done this job for 10 years and we're not prosecuting stalking as we should be. Stalking should be a felony when it's a repeat offense, and it should carry more time. So if we want to prevent intimate partner femicide, we need to deter stalking. And we need to incapacitate offenders when we need to before they murder their victims. Even if they don't murder their victims, the perpetual fear of being stalked forces a victim to change their phone numbers, pull their children out of school, change their address, go into hiding because they fear that the criminal justice system can't protect them from stalking. And we can't, and under the current state of the law. We need to join the majority of states that have enhanced penalties and protections for victims of stalking. Subsequent offenses need to be classified as felonies because, as my colleagues have said, felonies are treated differently by the police. They have a lot more resource allocated to them. A felony conviction reflects the true nature of the harm caused. It requires an intense amount of law enforcement investigation. We're talking search warrants, seizures of phones, social media preservations, multiple interviews with the victims. That type of resource allocation doesn't happen and doesn't go towards misdemeanor offenses. Parole and probation considerations, how much time someone's eligible for. And one point I want to make, under the current state of the law, Family Law Article 4506, you can get a permanent protective order for your lifetime if your offender is sentenced to 5 years for an act of abuse and serves at least 1 year of that. Stalking maxes out at 5 years. So even if you stalk someone multiple times, you can only get 5 years. So the victim has to make a choice. Either she gets no probation and the offender gets 5 years active, or she could get a permanent lifetime protective order. That puts her in incredible danger. And it essentially means that in the state of Maryland, you can never get a lifetime protective order if you've been stalked. Thank you.
Engler, thank you. Thank you very much. All right, that concludes the testimony of those people testifying in favor of the legislation. We'll go to the person providing informational testimony after questions here. The first set of questions, first starting with Delegate Anderson, then Delegate Juanita Fisher. Delegate Anderson.
Yeah, thank you, Mr. Chairman. First, I want to say that I found the remarks and testimony by all the state's attorneys extremely persuasive. And I'm certainly considering voting for this bill. I wanted to ask one additional question. That is, it sounds like one of the most important things to do is to get a subsequent offender off the street. Have any of the state's attorney's offices considered adding to this bill a provision for a mandatory minimum sentence on a second offense as a felony? And any state's attorney can answer that question.
I'm happy to start. That's certainly an interesting proposal. We're trying to take incremental steps along the way. Certainly having 10 years to work with versus 5 years is going to make a big difference. We had a recent case where a repeat offender, 2 convictions for stalking, and was quickly maxing out on both because stalking is not a crime of violence. You're only required to do a quarter of the time before you're eligible for parole. So we would be very grateful to have the additional time with a 10-year maximum penalty, at the very minimum now. I don't know if any of my colleagues feel differently or have something to add.
Okay, let me ask you a second question. I heard a couple of different of the state's attorneys mention that there were psychological evaluations done on the defendant prior to, I guess, sentencing, or is that a pre-trial? And if it is, what happens when psychological evaluation comes back that the individual needs some kind of mental health treatment?
So I'll answer part of that, and then the rest of my panel can hopefully chime in as well. So in cases where I've had psychological evaluations ordered, that's been after a plea or a finding of guilt and prior to sentencing. And that's so that we can get the psychological evaluation in to determine what is the most appropriate sentence in many ways for this case. And that includes looking at risk, recidivism, harm, and if there's an underlying mental health diagnosis that had not previously been diagnosed and that treatment's appropriate. And so we haven't had them in the beginning. Oftentimes, judges do not order psychological evaluations pre-trial unless it's in a very specific circumstance. So most of the time it's after a finding of guilt and while awaiting sentencing.
Okay. Thank you.
I'm sorry, Delegate Anderson, I just wanted to share some insight with my case and my offender. Ours was done pre-trial before plea and sentencing, but because of his increased behavior, that once he was locked up and held without bond and told by the judge multiple times to stop the contact, and his threats on the jail call were escalating to violence, to kill her, the witnesses, our lead investigator, if you will. The judge did order one pre-trial, pre-plea, but that it's rare that it happens that way. It usually happens, as Ms. Marsh says, as part of the pre-sentence post-plea. And what happened with what happened when the evaluation came? What was the nature of the evaluation when it came back? It was they labeled it as like a personality disorder. And so he wanted a shot at inpatient treatment before sentencing to make a good faith effort, I guess. So we did. We found a place that would take him an inpatient. He went, and that's when he persuaded his care worker to let him use the phone, and he called the victim from his care place. So the judge brought him right back to the jail. And would a minimum sentence help your cause as a state's attorney, or would it hurt it in terms of maybe trying to plea bargain away something? I think it would help. I think it would help us, and it would get the attention that is needed for the stalking in general. Okay, thank you so much. You're welcome.
All right. We'll go now to Delegate Juanita Fisher, then to Delegate Davis. Delegate Juanita Fisher.
Thank you, Mr. Chair, and thank you, Delegate Shetty, for bringing forth this important legislation. I think something that I'm struggling with the legislation, and that maybe the prosecutors can speak to, is I find, and I guess I'm limited in my perspective, mostly in my own practice experience, I guess I question the theory of, do bills make things a priority for law enforcement and for those that run our agencies? Because for me, for example, if I had to highlight trespass with people that are in substance abuse and sexual assault crimes on campuses in our state, I think there's a lot more sexual assault, potentially even stalking and rape happening at universities across our state. But are they really enforced in our local state's attorneys and law enforcement really making that a priority? But there's not really a bill to change, the incarceration or anything around, let's say, rape or sexual assault for today. It's really about, do you want to do that? Or is it easier in the public square to incarcerate someone or jail someone for the person who's on drugs, who's trespassing at 7-Eleven for the third time, and they're on the district court docket, right? And so I definitely am worried about women, in particular, their situation with stalking and repeat offenders. But I just think the policy point needs to be fleshed out a little bit more about how is this going to really how is this changing the amount of jail time and changing a misdemeanor to a felony going to make this a priority for state's attorneys to enforce, want to investigate, and make it a priority for them? Because I feel personally there are a lot of crimes right now that are felonies that have more jail time, that I think this committee, and I can speak for myself, would love to see that be a priority for enforcement. And so I think that's the piece that I would like to hear a little bit more about. Thank you.
Okay, wait, excuse me, Ms. Feinstein, I'd like to speak first.
Yes, of course, please, Delegate Shetty.
Thank you. First, Delegate Fisher, thank you for those very, very helpful remarks and feedback. I welcome it from all colleagues on the committee and friends. And so I want to first state that, as you know, I am not a practicing attorney. You have far more court experience than me, and I bow to you in that regard. You were amazing. But what I have learned from the conversations I've had with stakeholders on this bill is that in general, I'll tell you, I share your perspective. I don't necessarily always agree to bumping things up from misdemeanor to felony. I'm typically one to support the opposite, in fact. And I will say that I found it compelling that along with some of the factors that were shared by some of the state's attorneys on the panel, one thing that definitely caught my attention was moving it to a felony bumps it from district court to circuit court and gives judges a little bit more options for the post conviction time, and including potentially more supervised probation, which in these types of cases, I think is something that we probably could see some significant benefit from in terms of preventing the types of crimes that are actually happening right now. And so for me, that was a particularly compelling issue on that side. I agree with you. I don't know that necessarily a longer penalty is alone gonna change minds, but I just felt that the additional options available in circuit court, as well as some of the factors listed by the panelists was compelling to me. And I know Ms. Feinstein wanted to speak, so I apologize for jumping before you.
Oh, no, please never apologize. We appreciate your advocacy, Delegate Chetty. And certainly we're open, and I know that we're open to having conversations around, the length of the penalty and that sort of thing, because I know that that's been a concern of some of the legislators. Here's the way that I think about the distinction between a misdemeanor and a felony, to Delegate Fisher's point. Who investigates a felony versus who investigates a misdemeanor is dramatically different. The way that our police unit is set up, at least in Montgomery County, a misdemeanor is going to be handled by patrol, and a felony is going to be handled by a specialized domestic violence unit. And that is a humongous difference. The level, the quality of the investigation, no offense to patrol officers who are amazing, but they don't have time. We have the opportunity for more investigations, more subpoenas to go out. We have much more time when we're talking about a felony to prepare a case. We're not talking about, in pre-COVID times, a 30-day turnaround between arrest and trial. We're talking about much more time to be able to evaluate the case, subpoena phone records, subpoena social media, whatever it is that we need to support the case. And oftentimes stalking cases are incredibly complex and require a lot of data, because a lot of electronic communication, as I know we're going to hear later on House Bill 148. But the one thing that I also want to note, and we've already seen this happen, this legislature changed non-fatal strangulation from being a misdemeanor to being a felony 2 years ago. When I tell you the dramatic impact that has had on safety, on protection, on investigation, on actually figuring out what is going on in these strangulation episodes, I cannot understate the difference. Our numbers around the prosecution of non-fatal strangulation and the arrests related to non-fatal strangulation have gone up. Our documentation has changed so that we can collect that information. Detectives are now involved in those cases, and they were not involved before. We are getting violent offenders off the street or on probation, longer probation, because of that change in the law. I absolutely see this change doing exactly the same thing and making a real and true difference for our community. I'm sure that Ms. Marsh has things to add. I know that she feels very strongly about this bill, as do I.
I have just one additional comment. It's always hard to follow Ms. Feinstein, but one additional thing, when we are looking at individuals who have already gotten an order of protection from the court or have already had their offender or their abuser convicted once before of stalking, by increasing it now to a felony, we've added an additional protection, because once it's a felony, and if they are convicted of that felony, they can't possess a firearm again. And in my case, if we'd gotten a felony conviction on him, he wouldn't have had that gun. or we wouldn't have been able to purchase that gun that killed Tanya that day. And so by increasing this from a misdemeanor to a felony, we are providing added protections, because stalking is a crime of violence when we look at it in the repeat offender and the intimate partner violence world. And we just want to make sure we add those additional protections that this legislature has already deemed when we look at second degree assaults that are domestically related, that protect our victims and making sure they can't have firearms too.
Thank you guys. Thank you, ladies. I'm sorry. Thank you, ladies, for your comments. And I appreciate the endless hours. And I know the hard work that you all do to keep our communities safe. I used to do that, but now I don't. But yes, I really do appreciate it. And, you know, I was so happy our committee did that with strangulation. I was so supportive. My state's attorney, Aisha Braveboy, was such a champion on that. And so I really appreciate it. My follow-up question to you is, and you gave me a lot to think about, and I will be thinking about that. My second bite of the apple, sorry, Mr. Chair, is for juveniles. I'm just interested in the sense of how it would play out, in the sense of, you know, stalking is electronic, and you know, the texting, the calls, and how it can be, and with teen dating, and you know, a juvenile dealing with stalking and it being a felony. What do you see happening with young people, with our juveniles, and it becoming a felony, and sort of the dating and the sexting and all that stuff, you know, that goes on there? If you all have had any experience or could highlight that. And I promise it's my last question, Mr. Chair. Thank you.
So I'm talking a lot here, and I'm going to talk briefly and then defer to my other colleagues that are on this call, who do incredible work. The distinction between a misdemeanor and a felony in juvenile cases is much less dramatic. You know, what really the goal, as I know that you're aware, of the juvenile justice system is rehabilitation. So we're looking for solutions for a minor, you know, a child. And so the distinction in terms of the outcome, the penalty part, is less significant. However, you still have the same benefit of the investigation, the distinction in the investigation, and you get more time also to do that. And you have more opportunity to have a longer amount of time in juvenile, depending on what the charge is. So really, I think there's a parallel there. I don't know if my colleagues want to add anything on that. Well, I hope I answered your question.
Okay. All right. Now, Delegate Davis, please, with a question.
Thank you. Thank you, Mr. Chair. And thank you, ladies, for your work. I'm really excited that we're going to have some more conversation on this, because I really would like, even you guys gave compelling testimony, but, you know, there's always another side, right? There's always other considerations, not just the extreme cases, not that they don't matter, but that there are extreme cases. My question, and you've all alluded to it, I have two, if you don't mind, Mr. Chair, is something that my colleague, Delegate Fisher, referred to, was the internal policies regarding who prosecutes what. A couple of you pointed to the fact that you don't give, that some agencies, in some counties may not give the attention that they need to misdemeanors, even though it's the same darn crime. You understand? And so my question is it an internal policy problem? And does every jurisdiction have a specialized domestic violence unit?
I'll answer part of that and let people chime in, as I've had the benefit of working in 3 different jurisdictions in the state of Maryland, from rural, suburban, and a more urban. And I will say that each one of them did have a specialized special victims unit. Now, it does seem a little unfair that if it's stalking as a misdemeanor for a first-time offense, or stalking if we make it a felony for a repeat offender, that why would they be treated different? And unfortunately, to be realistic, it's a lot like a triage at an emergency room. Misdemeanors come into the district court. They're set in at a much sooner trial date, generally 60, 90 days from the time that it's charged. Generally with a misdemeanor, the police officer, as Ms. Feinstein said, it's a patrol officer. They'll drop the charging document. It'll go to a commissioner, and that case gets a court date right away. And it'll generally be handled by a district court attorney. When it's a felony in the jurisdictions I've worked in, and that, again, that's 3 different ones, the detective has to screen it with the state's attorney who handles the case, which means we review the case together. We determine, is there any additional evidence? We get a say in determining what charges should actually go before a grand jury before they're just taken to a commissioner. And then it is actually put before a grand jury to make sure that the citizens in the state of Maryland are also agreeing with those charges. And then it's being set in front of the circuit court. And as Delegate Shetty said, we do have added protections in the circuit court. We can have probation up to 5 years, which is just not the option at the district court level. And we can do some additional resources and work also with our victim advocacy that way as well. And I'll defer to anyone else on the panel.
I was just going to add that I don't think that we're making it a felony just to make it a felony to get more attention. What we're asking is to give more attention to the most serious cases, the cases where it's a repeat offense or where there's a presence of a protective order or peace order. That's what we're asking for. So it's sort of the triage that Ms. Marsh is talking about, but it's triaging so that we're looking at the person that's bleeding out versus the person that has an abrasion. So that's the comparison I would make. I see that Ms. Proctor is also unmuted.
Yes, Delegate Davis. I just wanted to add, and I'll highlight what Ms. Feinstein said is particular that they have an active protective order, which is bill. And I've seen routinely in Charles County when I was with Charles County, and then in St. Mary's as the person, the liaison with the SVU team, is the violation protective order for a subsequent offender. You can file the notice, which we routinely did in Charles and we do in St. Mary's. That raises it to a year, but you're still in district court on a misdemeanor. So to get over to circuit court, to get the attention of these repeat abusers is the goal of this bill, which is the severe cases, those that continue to violate a protective order with stalking behaviors, which escalates to the further violence on that victim. And that's, I just was going to say that we have tried actively, I know in Charles and now in St. Mary's, to handle it through other ways, that there are subsequent offender notices out there and available, but there's nothing for stalking. And that's where we're at.
Thank you. If I may, Mr. Chair.
Go ahead.
All right. Last question. Most of you have referred to that this bill points to repeat offenders, but as I read number 2, section 1, the person had an interim, temporary, or final protective order. So if you have a protective order and if you make calls, then you have created a felony. My question is, if you've handled these cases before, you know that people get protective orders and they make many phone calls back and forth. Not all threatening, but they make phone calls back and forth. And then that's a felony. So they've never been convicted of stalking before, right? The way I read it. Well, why don't you tell me? Does that count as a felony at that point?
Well, I would say to that, Delegate, that simply making phone calls isn't going to necessarily mean that we'd be able to charge them with stalking. There has to be a malicious course of conduct that either results in fear of death, fear of serious physical injury, or extreme emotional distress. So we're not talking about sort of that, sort of conduct back and forth that we do see sometimes, that actually ultimately even plays into whether we prosecute, any crimes related to that. So I think there is a heightened level. It's not just you get a protective order and you get back together, although, that's problematic because there's a court order, but that doesn't mean that it's going to be considered a stalking.
And I was just going to say, Delegate Davis, thank you very much for that question, because I think it's an important one. And I think it does go back to stalking has a very limited definition in the state of Maryland. And it has to be that continuing course of conduct that places that victim in fear of the bodily injury, death, sexual assault, or an imprisonment by that person. Anything outside of that doesn't meet our limited definition of stalking in the state of Maryland. So you might have a violation of the protective order with that repeat call, which is a 90-day offense, or if it's a subsequent offender, as Ms. Proctor said, that could go up to a year misdemeanor, but that's not going to raise to the level of stalking. And that's not the kind of behavior we would be looking to address with this bill at all.
But section 2, paragraph 1 does not include repeated offense. That's what I'm asking.
That's correct, Delegate Davis. That's correct. So this only addresses 2 specific instances of stalking, either those who are repeat offenses or those who are violating protective orders while stalking. It does not, yes, that is correct. Thank you.
Delegate McComas.
Thank you, Mr. Chair. Just a brief question. I know that stalking is very discrete behavior, but I think what I find so troubling is the fact that the high percentage of people that are seriously stalked have been victims of homicide. And I was wondering if there's been any criminology studies or FBI profiling or anything that would help to know which ones are the more serious than the not so serious. Because I think some folks that stalk, they're potentially more harmless because they're they're a little obsessive compulsive type as opposed to the person that's going to harm someone. And I just wondered if there was any way to distinguish when something's really, really serious, because a felony is people can. It's like, the calling back and forth when they're not supposed to have any contact with the person, and you find that they make calls anyway. And it's just like, they just can't stop themselves. So I'm wondering, is there any way that you as prosecutors and the victim and the police can kind of somehow discern one is hotter than the other case? Thank you, Mr. Chair.
So there are many studies with regard to stalking, and I know Delegate Shetty has some of these and can, I'm sure, share them if need be. What I can say is what they have found that stalking in an intimate partner setting tends to have a higher lethality than stranger stalking or just casual acquaintance stalking. So in that sense, oftentimes just the intimate partner setting can have a higher lethality when it comes to stalking. And part of it is the repeat nature of stalking. They have found that there are some people who, when it is kind of just, I don't want to say an over romanticized or something like that, stalking, and it's the first offense and they do not repeat again after that, they're obviously, they're a low risk behavior. Those who cannot comport their behavior after a court order, after being sentenced by the judge, after being provided services, all of those things do lead to a higher risk. That's also why this bill is extremely targeted for one studies have found to be a higher risk for those who are already in an intimate partner setting and with a protective order in place, or those who have been convicted of stalking before and are continuing to stalk, because studies have found those to be the most dangerous.
Okay, I don't see any further questions for this panel. We thank you all very much. And we are now going to conclude the testimony on House Bill 110. Thank you very much, Delegate Shetty. We're now on to the last bill of the night. There are 14 witnesses. This is a new bill, three minutes for the sponsor, 2 minutes for everybody else. I think we'll just split the witnesses group in half. So we'll hear from Delegate Bartlett, then Lisa Jordan, Debbie Feinstein, Sheriff Darren Popkin, Sarah Proctor, Dorothy Lennick, Michelle Smith. We'll hear from all 7 of them, 3 for the delegate, 2 for everybody else, and then we'll do the next panel. Okay, and yeah, let's go ahead and start with Delegate Bartlett, and then we'll go from there. Delegate Bartlett.
Thank you, Mr. Chair.
Oh, wait a minute. I'm sorry. I've just been told I've made a mistake again, because we did have a person who was here to provide informational testimony and I skipped them on Delegate Shetty's bill, and that was Megan Tarquinio. So I have to stop and go back to House Bill 110. I forgot. I left her off. I apologize for that. Ms. Tarquinio, for 2 minutes, please. We'll hear from you and see if people have questions. I do apologize for that.
No problem at all. Thank you for the opportunity to speak today.
My name is Megan Tarquinio. I'm a licensed social worker. I've worked with victims of intimate partner violence, sexual assault, and child abuse for over 10 years now. The most dangerous time for victims of intimate partner violence is when they are trying to leave their abusive partner. At the heart of all of this is power and control. So once they've lost that power and control over their family, they resort to stalking. I've worked with so many patients who have come in upset and scared and have been concerned that they're being tracked. I sent a woman recently to a mechanic because her husband, who she had a protective order against, just ended up at the grocery store and CVS and her children's football practices. And we realized that she had a tracker on her car. So this makes it almost impossible for these victims to move on. It forces them to live in this hypervigilant state. It can make post-traumatic stress disorder last longer, and it can make it much harder for them to recover. So it's important that you know that this happens a lot and that there are so many people who are trying to get away from this and don't have much recourse. Thanks.
All right, thank you very much. I do apologize for skipping you there before we finished on that. Does anybody have any questions for Mr. Quinio? Seeing none, we do thank you for your time. Thank you for sticking with us, and I'm grateful for your testimony. All right, now we will go to House Bill 148. Delegate Bartlett. We'll begin with Delegate Bartlett and the order of witnesses that I've already stated. Delegate Bartlett, please go ahead for 3 minutes.
Thank you, Mr. Chair, and to Vice Chair Moon and members of the Judiciary Committee. For the record, I'm Delegate Sandy Bartlett, and I ask you to vote favorably on House Bill 148, designed to alter the definition of stalking. I also want to thank our former Vice Chair, now Chair Atterbury, as she was the original sponsor and has entrusted me with this important bill. There are great advocates and experts who will testify today in support of this bill without opposition. And in fact, some of the panelists who were on the previous bill were alluding to House Bill 148 and stole some of my thunder, actually. I'll just set it up for the members of the committee before the panelists testify, and then if you have any questions, we'll dive deeper. So we just discussed the penalty clauses of the stalking statute. And as the state's attorney has defined stalking as in current Maryland law, it is a malicious course of conduct that involves approaching or pursuing another, intending to place or reasonably knew that it or should have known that the conduct would place a person in reasonable fear of those applicable crimes and situations that are enumerated in the law. It is important to note that malicious conduct is defined as intentional, wrongful act done against another to cause harm and done without any legal excuse. The term course of conduct means a pattern of conduct composed of two or more acts. And so to show a continuity of purpose. I'm giving you this background because House Bill 148 does not change any of these elements, and it's important to understand the purpose of this bill. House Bill 148 adds to the definition situations where the stalking is in person or by electronic communication. And electronic communication, as defined in Section 3805, is a means of transmission of information, data, and you're going to hear some examples in by this electronic means. House Bill, and I will add that a very wise person was saying to me in support of this bill how everything is electronic these days, and it has unfortunately become a stalker's paradise to use electronic means. House Bill 148 is intended to update the law so that it will include those situations in which a bad actor commits a malicious course of conduct. And it is important to remember that, as with any intentional crime, There must be proof of intent and proof of the action. So please listen carefully to the statistics you're going to hear from the panelists. The frequency in which electronic communication is used to intentionally put others in fear is alarming, as you just heard as well with the panelists. And the panelists will give you ample evidence and reasons why House Bill 148 should receive a favorable vote. I thank you, Mr. Chair, and I'll be around if you have any questions.
Thank you very much. We'll go now to people here to testify in favor of the bill. I understand that I'm having a day. Sheriff Popkin is no longer here. We don't see Sarah Proctor in the waiting room. Don't know whether she'll show up here in a second. So we may add a couple more people if we can. But in the meantime, for 2 minutes, please, Lisa Jordan.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault, and we're here in support of House Bill 148. Thank you, Delegate Bartlett, for bringing this bill. I also want to thank and acknowledge my colleague, Dorothy Lennick, who's really been championing this and can give, I'm sure, more details than I can. But I did want to share these things with the committee. In 2018, 10% of stalking victims reported being monitored by GPS, and 8% reported being monitored through video and digital cameras or listening devices. But that was 2018. In 2022, after 2 years of being in the pandemic, living our lives on Zoom and having increased technology, it is, as Delegate Bartlett said, a stalker's paradise. And I especially wanted to point to Apple's AirTags. So if you haven't heard of these yet, they're little devices and you can just drop them in your purse or your suitcase or your child's backpack, so you can find it in case it gets lost or misplaced, which is, of course, a lovely and benign thing to do. Unfortunately, stalkers are using these to track the people that they want to track, and it's extremely convenient. It's as if it was made for them. You'll hear from many of my colleagues about domestic violence cases, about intimate partner cases, but I also wanted to share with you the non-intimate partner cases. So at the Maryland Coalition Against Sexual Assault, we have the Sexual Assault Legal Institute. We help survivors all over the state of Maryland, including college students, all sorts of people who are being sexually assaulted. And many of them are telling us that they are being stalked, not by an intimate partner, but the person who assaulted them or who is stalking them or who is harassing them are people they barely know. They're people who maybe asked them out and they declined to socialize with them. And for these reasons, we really need to modernize this stalking definition just to recognize what's going on in today's world. And I think it's very important to notice also that when you change the stalking definition, you also change when you can get a protective order and when you can get a peace order. I've practiced all over the state of Maryland, and I can say in particular that my clients who are Black and brown women and do not want to use the criminal justice system, it is extremely important that we have this option of seeking a peace order, seeking a protective order. So for those reasons, I ask for a favorable report on House Bill 148.
Thank you very much. Debbie Feinstein for 2 minutes, please.
So sorry. Good afternoon again. You all have probably had your fill of me speaking. As you know, I'm from Montgomery County State's Attorney's Office, and I'm testifying on behalf of myself and my boss, Mr. McCarthy. I should have mentioned that when I testified on the previous bill. I liken these definitions, again, back to what I was talking about with non-fatal strangulation. Naming it, saying it makes a difference for our ability to prosecute, to hold offenders accountable, and to target what we're looking at when things are being investigated. I can say pretty confidently that almost all of our stalking cases include some component of electronic communication, whether it's through social media, phone calls actually, but more often instant messaging, following someone through their iPhone, Find My iPhone, the use of these AirTags and tiles that Ms. Jordan spoke about. I actually had several conversations with one of the captains in Montgomery County in the last 2 weeks about the prevalence of these AirTags and the prevalence of something called a tile that can be just dropped in someone's purse or bag or on their car. We are seeing that more and more and more. And as we've described before, stalking is dangerous, particularly for victims and individuals that are involved in intimate partner relationships. I will cede my time to the other people that are testifying, but I would strongly urge this committee to support House Bill 148. Thank you.
All right. Is Sarah Proctor here?
Chairman, I had some trouble getting back in. I'm not sure if she's having the same trouble. I can try to send her a message.
That's fine. If you do that, that's fine. We'll go now, though, to Dorothy Lenig. And if I could make sure that Michelle Smith and Rebecca Snyder are in the room, that would be fine. Dorothy Lenig for 2 minutes, please.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Dorothy Lenig. I'm the director of the legal clinic at the House of Ruth. I'm here today to urge a favorable report on House Bill 148. I want to thank Delegate Bartlett for introducing this bill. As she described to you, this bill amends the definition of stalking to include electronic communication and placing a tracking device on somebody without their consent. Currently, the law requires somebody to physically follow somebody or pursue them. And while Ms. Feinstein, I guess, is maybe successful in prosecuting stalking without that physical following, in some jurisdictions, people are not as successful. This bill, stalking was originally enacted in the 90s before there was all this electronic communication and these kinds of tracking devices. And so people really did follow each other. But nowadays, almost all of it is electronically. Lots of people are going to testify about the horrors of stalking. So I just wanted to make a few points. One is that this changes the definition of stalking, but it doesn't change any of the other requirements of stalking. So you still have to show that the person put the other person in fear of an act of abuse or fear of serious emotional distress. So you still have to prove that. Also, it doesn't change the part, you're still allowed to follow somebody. It is not stalking if you're complying with a court order or carrying out some other commercial legal purpose or if you're authorized by law. So that's still allowed. Stalking, harassment, and misuse of electronic communication are all different crimes. They all have different penalties. They all have different elements that the state's attorney has to prove. And so if you have questions about how each of those are different, please feel free to ask one of the assistant state's attorneys. And finally, for old-fashioned people, it would still be stalking to physically pursue somebody in person. So we haven't changed any of that. So let's bring stalking into the 21st century. I urge a favorable report on House Bill 148. Thank you.
All right, thank you very much. We do not, I think you can hear me now. We do not have Michelle Smith in the waiting room. We're going to go to Rebecca Snyder, and then we'll take questions. We'll just stop right there. So Rebecca Snyder, please, for 2 minutes.
Good afternoon, Chair Clevenger and members of the committee. I'm Rebecca Snyder. Today I'm here on behalf of Executive Alliance, which is a professional women's organization that is focused on changing the conversation about women in Maryland's workplaces. We do that by elevating women leaders to boardrooms and executive leadership roles. And we've heard so much about stalking and its effect on women, and the statistics and stories that we heard in Delegate Shetty's bill and in this bill are stunning. But it's also a workplace issue. So we are pleased to support House Bill 148 because it strengthens the definition of stalking. It's a significant workplace issue, and you can read facts and figures in my testimony. But if you think about it, many victims are forced to change their jobs, even their careers, and do this over and over and over again. And so when you think about that, stalking really holds women back. You know, they cannot realize their full potential in the workplace if they're constantly being undermined and having to flee their workplace. Maryland businesses are also more vulnerable because of stalking. I think a previous speaker talked about how stalking turns violent very, very quickly. Nationally, about 44% of stalking incidents result in workplace violence, and a victim will lose about $730 in productivity each year. And so when you think about, you know, the very real threats of violence that are occurring in workplaces and the loss of productivity, it becomes, and extrapolate the fact that 1 in 6 women will be stalked in their lifetime. Those numbers are staggering. And so we need to have these protections in place to make sure that women have the tools, all the tools that they can to fight against their stalkers. So we urge a favorable report, and I'm happy to take questions. Thank you.
All right. Are there any questions for the panel? Delegate Howell.
Yes, I just wanted to say thank you for your testimony. And I also wanted to say that I hope that when we're talking about stalking, we keep in mind that men also are stalked, and we should, we should always include them in our talks. Thank you.
Thank you. Are there further questions for the panel? Seeing none, we thank you all very much for your testimony today. And now we'll go to our final panel for the afternoon, soon to be evening, but that's okay. We'll hear from Catherine Marsh, Lori Ruth, Brett Engler, Jody Kavanaugh, Melanie Shapiro, Jessica Emerson. If Michelle Smith or Sarah Proctor are able to get in, we'll let them testify too. Committee, I do need to step away. So the Vice Chair, Delegate Moon, will be taking over for me now and taking us through this final panel. So I'll send it over to Delegate Moon. But in the meantime, let's begin with 2 minutes to Catherine Marsh, please.
Thank you. It's a pleasure to be back again. I'm Catherine Marsh, Special Victims Liaison with the Charles County State's Attorney's Office. To highlight the question from our last delegate, one of the statistics that we have most recently on stalking has 1 in 6 women and 1 in 17 men. So it is prevalent with men as well. And it is important that we recognize that and we don't leave our male victims out of the conversation. A recent study by the Women's Services Network found in 2020, 33% of frontline workers saw victims of intimate partner violence being tracked with GPS apps or other devices. In 2015, the study found it was only 8%. So we can see how much that has grown in just 5 years. The same study found that in 2020, 42% of frontline workers found surveillance cameras being used to monitor victims of intimate partner violence. And yet Maryland, along with Louisiana and Rhode Island, are the only states that have not yet amended our laws to specifically account for the use of technology. When we talk about statistics, it's important to know that the average length of time a victim of intimate partner stalking is stalked is 2.2 years, and a victim of non-intimate partner stalking is 1 year. And almost every single case I review with stalking, elements of electronic communication tracking apps or devices are used, from actual spyware and stalking apps that are put on the victim's electronic devices. One that we had actually can track the victim's calls, all of their text messages, can actually activate the microphone on their phone so they can remote listen to anything that the victim is doing when they have their phone with them, to the cheap and easily accessible GPS devices that Ms. Jordan and Ms. Feinstein talked about that they see in their cases quite frequently. Technology is just a part of our lives every day, and it's a part of the stalker's life every day as well. And I urge a favorable return on this bill. Thank you.
Thank you. I think we now are going to folks that were skipped last time. Dorothy Lenig.
I testified already. Thank you.
Excuse me. And Michelle Smith.
Thank you, Vice Chair Moon. I had some technological problems getting back in, so there you have it. It's so timely. I am Michelle Smith. I'm here on behalf of Maryland State Bar Association Family and Juvenile Law Section Council. I thank you for listening. I'm going to cede most of my time because the other panelists have said it all. But in the divorce and custody context, as litigators, we are seeing these types of behaviors used by perpetrators against our clients. And in the current environment, we need an update to this law. So we urge a favorable report on House Bill 148. Thank you so much and good evening.
Thanks. I believe next we've got Lori Ruth.
Good evening, Mr. Vice Chair, members of the committee. My name is Lori Ruth. I'm the legal director of the Women's Law Center of Maryland. In the interest of time, I will just say that Catherine Marsh's list of the way that these things happen was very thorough. It really has to do with the cell phone, right? Everybody has a cell phone. I remember when I used to testify down in Annapolis 10 years ago, we heard testimony about somebody sitting at the top of the cul-de-sac where somebody lived, essentially watching them, stalking them. And that was horrifying, and it caused that woman a tremendous amount of stress. It does cause the hypervigilance that the prior bill informational witness testified about. It's exhausting for victims when they're being stalked. And now it is mostly all electronic. It is often involved with the cell phone. Similarly, 10 years ago, we had clients who didn't have phones. Now everybody has a phone. I really think that it's become, pervasive in all economic, in all cultural, in all, everybody pretty much has a phone. And there are products that are sold by the producers of the phone that are then used to stalk the owners, especially if you have a common account and for many other reasons. So I just refer you to my written testimony. There's a website called techsafety.org. It was operated by the National Network to End Domestic Violence, and it goes through all the different technological ways that stalking is happening all the time, every day. Our cases have elements of stalking in them all the time. And for all of these reasons, we urge a favorable report. Thank you.
Thank you. Next, we have Brett Engler.
Hi, thank you all for hearing from me again. I'm Brett Engler. Can you hear me better on my phone? Hopefully. Hi, I'm the Chief of Domestic Violence here in Frederick County. On behalf of Charlie Smith, who's the state's attorney, we urge a favorable recommendation. I told a victim of mine in 2019 that I would share some parts of her story. She was a frontline healthcare worker in the pandemic. She dated a person for about 3 months, and he became obsessed with her. She had broken up with him. She got obsessive phone calls, texts, social media messages, emails. He tried to ruin her reputation because she wouldn't stay with him. He continuously spoofed numbers to try to get her to answer his calls. She got a protective order, ultimately felt bad that he might lose his job for having a protective order against him, so dropped it. But instead of being kind to her, he kept stalking her. She felt like someone was following her. She would tell patrol, to the earlier points we made. Patrol officers, because they shift so often, are not able to follow up with a victim in the same way a detective could. She felt like she was being followed, but she couldn't necessarily put it all together. We eventually got her to a detective, and they were able to do the work to prove stalking in this case, or to attempt to prove stalking. But ultimately, she wasn't satisfied with the time that we could get, but because of the bill we testified to earlier. Ultimately, a tracker was found on her car. A search warrant was done for who put the tracker on the car. The person who had bought that tracker came back to the offender. He was slashing her tires, putting spray paint on her car, calling her all types of names. And I said to her that I would read part of her victim impact statement. Ultimately, to my point earlier, we pled that case not to stalking, even though it was stalking, because the law is so outdated that the tracker was the key to our stalking case, and it really is not encompassed, and our courts have not necessarily seen that as stalking under the law because our law is outdated. She told the court the following: "I'm terrified every day that he was out of jail," and he didn't serve much jail, to our point on the earlier bill. "The day I see him in public or in the community, I don't believe that this will end. I weigh whether I'm going to leave Frederick, my loved ones, my life, my family, in order to feel comfortable again living. He'll always make me walk cautiously, date cautiously, trust cautiously, and feel uneasy in my everyday life. Mental and emotional anguish he has caused from the time he's stolen from me, the space my soul cannot be replaced. It was taken from me unwillingly. While the plea only shows guilt to a repeated offense of violating a protective order, it is the stalking and the harassment that forever changed my life. I believe he deserves all of the charges brought against him." So we asked the legislature to fix the law so it accurately reflects what my victim went through and the modern day stalking strategy that's ruining lives. Thank you.
Thanks. Next, we have Jody Kavanaugh.
Good evening, Vice Chair and members of the committee. My name is Jody Kavanaugh, and I am the Director of Legal Programs at Midshore Council on Family Violence on the Eastern Shore. This evening, I'd like to share a survivor's story with you as well. Her name is Barbara, and she's a resident of Easton. She lived in California with her abuser and decided to flee the domestic violence she suffered. She received a call not long after she arrived in Easton from mutual friends of hers and her abuser, And they told her that they had gone to dinner with him and that he had been acting bizarrely and was speaking as if he had become obsessed with her. They also told her that he was on his way to Maryland. She, of course, became terrified. She knew of his troubled past, of his troubled and trauma-filled childhood, and she knew of the abuse that she suffered at his hands. She also knew that he had no business in Maryland. He had no family in Maryland. He had no employment ties to Maryland. In fact, he was from England. So she did exactly what we would ask any victim to do. She went to the courts. She applied for a protective order. She changed her, she blocked him from all her social media. She got a post office box, but her abuser was very clever. He sent items to her, personal belongings to her post office box. And in one of those boxes, he included an electronic device, a tracking device. She took that box home and opened it. And in a hat, in the brim of a hat, he had placed a tracking device. So he now knew where she lived. And she knew he was on his way to Maryland. She tried again, like I said, she went to the court to try to get a protective order to keep him away from her, but she was denied. The protective order, of course, requires imminent fear of harm, and her abuser, as far as she knew, was still in California. Barbara was left with no protection, and unfortunately, her abuser was probably on the way. We at MidShore Council on Family Violence support House Bill 148, and we urge a favorable report. Thank you for your time.
Thank you. Next, we're going to go to Melanie Shapiro.
Thank you. Good afternoon, Mr. Vice Chair, members of the committee. I'm Melanie Shapiro, Public Policy Director with the Maryland Network Against Domestic Violence. I apologize, I did not see which delegate made the comment earlier regarding this not being a male or female issue, that it is an issue that impacts both of them, because that is one of the points that I wanted to make with you. Stalking impacts 61% of female victims and 44% are male victims. And so this is an issue that impacts everybody. And I'm not going to repeat what all of the people prior to me have already testified to, but I will share with you that studies show that 76% of women who were murdered by an intimate partner were previously stalked. It's also an indicator of other forms of intimate partner violence, with 81% of women who were stalked by a current or former husband or partner or cohabitating partner also reporting that they were physically assaulted by that stalker. And the last thing that I will ask all of you to do if you have a moment is to Google Apple AirTag and stalking, because what will come up is that just this week, they released a personal safety guide because of how prevalent Apple AirTags are now being used for stalking. And what I would hope, and what this law accomplishes, is it simply updates the law to reflect what the current practice is. And perhaps it's a good thing that I didn't prepare my testimony until this afternoon, because I put that in and looked up AirTag, and this was literally released this week. Other states are reporting this as an issue. It's being reported, and Apple is even responding. They did an alert that they put so that people will know if it's been dormant for a certain period of time. So for all of those reasons, we urge a favorable report on House Bill 148.
Next, we have Jessica Emerson.
Yes, good evening, Mr. Vice Chair, members of the committee. My name is Jessica Emerson, and I direct the Human Trafficking Prevention Project at the University of Baltimore School of Law. In partnership with the Maryland Volunteer Legal Lawyer Service, the HTPP works to reduce the collateral consequences of criminal legal involvement for survivors of human trafficking and those populations put at highest risk of exploitation. I am also here in support of House Bill 148. In addition to what my colleagues have already shared, I'd like to highlight the risks faced by a population that has yet to be discussed, which is people who trade sex. And this also includes those who do because they're being trafficked. This population is put at heightened risk of electronic methods of stalking and surveillance, given that they routinely rely on the internet to connect with customers, a practice which exposes them to very unique online safety and privacy challenges. In fact, given that the practice of sex work is primarily conducted online, studies conducted on the experiences of people who trade sex frequently report online-based crimes, And a recent study from the UK reported that 2/3 of the individuals surveyed reported online harassment and stalking behaviors. Given that this population is also incredibly hesitant to engage with the criminal legal system, given the illegality of sex work, allowing these individuals to pursue a civil protective order to protect against this type of unwanted behavior would be a huge change for the better. Stalking is also frequently reported by survivors of both sex and labor trafficking, a crime which is, by its very definition, largely accomplished by surveillance as a method of control, from the recruitment and grooming of a victim through to methods of intimidation that are used if the victim attempts to flee. Stalking behavior, both old-fashioned physical stalking and also electronic, is common and effective. House Bill 148 would build on this existing law by acknowledging that our current digital age exposes all of us to greater risk of digital tracking and surveillance. And this will in turn open up legal avenues for victims of stalking, including people who trade sex and victims of trafficking, to report unwanted surveillance and tracking. So for these reasons and the reasons that all of my colleagues have already covered, the Human Trafficking Prevention Project at the University of Baltimore School of Law supports House Bill 148. We respectfully urge a favorable report and thank Delegate Bartlett for her leadership in sponsoring this bill. Thanks.
Thank you. All right, I think that's all of our witnesses. Are there any questions for this panel? All right, looks like I don't see any questions, and we appear not to have anyone signed up in opposition. So that's going to end the hearing on House Bill 148. This is also the last bill of the evening. So with that, we will end, and I believe we're reconvening next Tuesday at 1 for additional hearings.